Good morning. Good afternoon. Good afternoon. I just looked at my non-existent watch. I think it's about noon. Getting close to noon. Anyway, I just watched a video from Delete Laws. It had three major points to it. Point number one is that cops can't solicit a trespass. It's a federal crime. Well, I challenge that assertion. Show me one time, one case where a cop was charged with soliciting a trespass as a felony, as a federal offense, even a misdemeanor. I don't really care. Just show me one time where a cop was charged with it. Now, you might say that the cop should be. Okay, I can't argue with that. That's your opinion. But as a matter of practicality, no, cops don't get charged with it. That's a problem right there, isn't it? You can't show one. He didn't show one. He read something that somebody wrote. It was basically an argument on why they should be. I disagree with it. And I'd point you to, I want to say Bartlett v. Neves, but it might be Neves v. Bartlett. I always get the names on that one flip-flop, but I'm going to call it Bartlett v. Neves. And Bartlett v. Neves, the Supreme Court held that it doesn't matter what the subjective intent of the officer is when he makes an arrest. If he has probable cause to make an arrest and he makes an arrest, that's it. The only inquiry the court makes is, did he have probable cause? If he had probable cause and he made an arrest, perfect. If he didn't have probable cause, well, then you got a problem. But his subjective intent, like, is he just mad? Is he singling this person out? Is it, why is he doing it? Doesn't matter. That is not something the court looks into. So if you're trespassing, if you're someplace where you can be trespassed from, and the officer asks a person who has the authority to trespass you, do you want this person on your property? And they say no. The cop says, do you want him trespassed? And the person says yes. Then what? What are you going to do? Nothing. That's what you're going to do. You're going to do nothing. It's all talk. It's all talk. Show me. The proof is in the pudding. Show me the pudding. Show me the case. Show me any case. The second thing is Auditors United. Apparently, Chille's associated with the group because he could get enough people to pay for him to write complaints for him. So now he's associated with an anonymous group that's going to prepare complaints. I remember I was approached by one of those anonymous groups to represent auditors back when I first started making videos. I forget the name of it. And then I remember, what was that fat guy's name? God, Ben Navarez, Black Label Cop Watch, Fat Label Cop Watch, something like that. He started one. I forget what he called it, but it was a pure grift. They're all pure grifts. This one's going to be a pure grift. You got to remember the easiest thing to do in the whole chain of a lawsuit is to prepare and file the complaint. Easiest thing in the world to do. The bar to it is very low in the federal court. Now, responding to all the motions to dismiss, that's where it gets kind of trickier. I mean, look at your boy Delete Laws. How many times has he had to file First Amended, Second Amended, Third Amended bullshit? Look at your boy Mark Stout. Again, it's a problem. These people don't know what the fuck they're doing, but they're going to go and charge you money so that they can write shit complaints for you so that you can have the exact same amount of trouble getting past the 12B6s to get actually to trial. Actually, to get to discovery. I mean, let's be honest. Like, these people have no idea what they're up against. No idea at all. They got a long road to hoe. Chille's got a long road to hoe before he gets even close to trial. Mark Stout, I don't think he's ever gotten to trial. I mean, there's a lot to do. And I've seen Chille in a civil harassment restraining order hearing against Kate. And Chille sucked. He didn't know a damn thing. He didn't know how to ask a question. He didn't know how to answer a question. He didn't know how to present. He didn't know how to present any evidence. He didn't even know how to submit the evidence to the court for it to be used as evidence. He didn't know a damn thing about a damn thing. And that's in a relaxed kind of environment. The civil harassment restraining order hearings, they've relaxed the rules of evidence to accommodate just your average Joe showing up, making his argument, and maybe getting a restraining order. The federal rules of evidence in a defamation or a 1983 lawsuit or a copyright lawsuit, they're going to be in full force and effect. And Chille is going to run face first into a lawyer who's going to be objecting, and Chille's not going to know what the fuck to do. Chille won't know how to prepare. anything. He won't know how to ask questions without being leading or compound or whatever. I mean, he's just going to run face first into a wall of objections that he's not going to know how to overcome. So it's a big pile of nothing. The third thing is the right to film in court. Now, one would expect, if there was in fact a right to film in court, if the Supreme Court had said there is a right to film in court, that number one, you'd be able to film in the Supreme Court. You can't. You can't even bring a tape recorder into the Supreme Court. You could bring a pencil and a piece of paper. Why is that? Well, because you have a right to access. If you listen to all the cases that he's quoting, you have a right to access. The courts have found that there is a Sixth Amendment right to access criminal trials, and there's a First Amendment right to freedom of the press. That gets you in there. That allows you to gather the information, to disseminate it. It doesn't mean you have unfettered means by which to gather it. There's what's Chandler versus Florida, I think, and what's one out of Texas? There's another one out of Texas where they turned the news media turned a trial into a circus, and the Supreme Court is basically like, yeah, the court has to control filming in the courtroom. And Chandler versus Arizona, I think, is the other one where Florida had rules about how you can film in the courtroom. And the Supreme Court says, well, that's fine. You can make the rules. And as long as it doesn't impinge upon the right to a fair trial that the defendant has, then the court can allow filming. The court can allow filming insofar as it doesn't affect your right to a fair trial. The court can allow it. The default is you don't have a right to film in there. You have a right to access. The default is you don't have a right to film. Show me a court show me any circuit anywhere where they found you have a right to film. You notice how none of the cases he cited had to do with actually filming in a courtroom, but they all talked about the right to access. There's a difference. If you were an actual constitutional law scholar, you would understand the difference between filming and the right to access. And you'd also be able to explain why the Supreme Court, if in fact it allowed filming, would not allow filming in the Supreme Court and what the difference was. But there isn't. It's just a court. The Supreme Court doesn't allow filming in its courtrooms. Federal courts don't allow filming in their courtrooms. Even in California, like Placer County doesn't allow filming in the courtrooms. Sacramento County doesn't allow filming in the courtrooms. I don't know of any counties that allow filming in their courtrooms. I have filmed inside of a courtroom in Placer County in the historic Auburn courthouse inside the courtrooms, but I asked permission from the judge to do it, and I didn't do it while there was a case pending, and it was because it's beautiful, and they're the work they've done restoring the historic Auburn courthouse. But the default is you can't film in there. The default is you can be in contempt of court if you film in a courthouse. The primary function of court is to ensure justice, not to let you film. Now, you might say, why can't a defendant film? I don't particularly know. I mean, in some circumstances, I would say that there's probably nothing wrong with having the defendant film. But in other circumstances, like if there's a jury, I can understand why there would be a problem. I mean, remember in Earl's trial, all the jurors were concerned about their identities getting out. And they didn't want the court to name their names, and they didn't want to be filmed. You know, if you want justice, you got to have jurors who have anonymity so they don't face repercussions for making the wrong decision. Anyway, Chille's a doofus again. He has no idea what he's talking about. He's just talking out his neck. And one of these days, it's going to catch up to him. I mean, sooner or later, he's going to try to film in court, and the judge isn't going to have any of it. And I guess we'll find out if he's live. If he's not live, then I'm sure he'll hide that fact from us. Anyway, thanks for watching. Have a great day.